Ladies and gentlemen,
Good evening.
Are you ready?
Okay, here we go.
You're listening to the Deal Room Podcast. Join us as we bring you the inside scoop on business sales and acquisitions. Get across trends in the area and hear the industry's best recount their real-life tips, traps, and experiences. Now, here's your host, Joanna Oakey.
Hi, it's Joanna Oakey here and welcome back to the Deal Room Podcast, a podcast proudly brought to you by our commercial legal practice, Aspect Legal. Now, today we have a very topical podcast for you, all about transactions involving foreign investors and in particular, the FIRB approval process that has changed, or indeed in particular, the threshold that has changed in relation to the FIRB approval process in the recent COVID epidemic. So today we're talking about the changes that have come into play in relation to the FIRB approval process and the FIRB approval thresholds. And we are also just looking at foreign investment and the processes and thresholds as a whole. So to talk about this topic, we have on board Jo Wright from our very own Aspect Legal. So let's launch straight into it with Jo. Hi, Jo. Welcome on to the Deal Room Podcast.
Hi, Joanna. How are you?
I am fabulous. Thank you so much for joining us today. Now, Jo, how about you kick it off by, why don't you give us a quick background of your experience in the FIRB space?
Okay, sure. I started my legal career at Mallisons, King & Wood Mallisons, and was predominantly in mergers and acquisitions, but a large part of that work was with their foreign investment team. And I worked for probably 4 to 5 years doing foreign investment applications to Treasury, and I'm working on a range of matters from acquisitions, business acquisitions to land acquisitions, unit trusts, Australian land holdings, various range of acquisitions, and dealing with clients from both foreign investors as well as foreign government investors. So dealt with probably in my time, I think roughly 150 FIRB applications while I was at Mallisons, ranging from all sorts of different transactions from property to corporate to land acquisitions. So quite a diverse range.
Great. Okay, wonderful. And look, the reason why we're talking about this obviously today is because the big news of the moment is the new provisions and the temporary provisions that have come through, changing the thresholds that apply to the requirement for getting FIRB approval for acquisitions in Australian businesses by foreign investors. So maybe can you give us a little bit of an overview of what the position was prior to these changes, and then also we'll then start to delve into what the changes are. So prior to, now, what was the date? It was the end of March, I think, that that these changes came into place.
Yeah, so on the 29th of March, the Australian government announced 2 significant changes to the foreign investment regime. So prior to that, if a foreign investor wants to acquire a business or an interest, whether it's land or business or property in Australia, then they need to go through and see whether the transaction is a notifiable transaction under the relevant legislation, which is the Foreign Acquisitions and Takeovers Act, or everyone calls it the FATA. So if the acquisition is either voluntarily notifiable or compulsorily notifiable under the FATA, then it's usually a transaction that goes for FIRB approval. And basically the way that those acquisitions work is that there's usually a monetary threshold. So if an acquisition hits that monetary threshold, then it will be notifiable. And then the second criteria is whether the person is acquiring enough of a percentage interest in whatever they're acquiring. So whether they're acquiring, say, a 25% interest in a business, and that would trigger the notification, as opposed to a 10% interest, which is lower than the threshold. So what the government did on the 29th of November was basically remove the monetary threshold for all investors and remove it down to a 0 threshold. So if there's a foreign investor that, whether it's foreign government or an individual or a corporation and they're acquiring an interest in Australia, then there is no monetary threshold that applies at the moment for the next 6 months.
Mm-hmm. But we still have the proportionate ownership threshold.
Correct. So there's still the proportionate ownership threshold. So they need to be acquiring, depends on who the investor is. So if it's a corporation or a foreign person, then they need to be acquiring, in terms of a business acquisition, more than 20% of that business. If they're a foreign government investor, then their direct investment criteria still applies, which is 10% of a company. There's different thresholds for land. So any acquisition in land, there's no percentage interest there. So that still applies. So it really comes down to businesses. The second the second big change they made was the notification or the processing time that they will take to process an application. So usually the turnaround time for FIRB is 30 days that they will get back to and approve an application, whereas now they've extended that out to up to 6 months. But having said that, even though they've made that change in terms of the time frame of up to 6 months, it's unlikely that, it depends on what the transaction is, but it's unlikely that some transactions will take that full 6 months period to get approved. But it does come down to what the nature of that transaction is.
Sure. I mean, you know, that's a long period of time, though, that it could take, isn't it? So I guess that's why it's really important that professionals who are engaged in dealing with businesses that might be selling to a foreign investor have to be, or you know, acting for the foreign investor on the buy side, have to be aware that there might be significant delays in the timing of completion whilst the FIRB approval is dealt with.
Yeah, that's correct. But it depends on the transaction, and if the transaction is designed to stimulate an Australian business or to stimulate jobs or retain jobs in Australian business, and there's an urgency to that transaction going ahead, then there's a chance that it will be processed within the 30 days. And in fact, I've seen some transactions that have been turned around within a matter of days over the last few weeks since those changes have come in. And those transactions have been deemed urgent because they are designed to fit into the government's criteria in terms of stimulating Australian businesses and retaining jobs. So if there is a priority in that area, then they will process them quickly. But so if there's a transaction that will protect and support Australian businesses and jobs, then it will get a higher priority in the processing. If there's a transaction that, say, it's an internal reorganisation or it's an internal reorganisation that will trigger the FIRB notification, or it's for, say, tax purposes, then that's unlikely to be processed anytime soon. And that will be falling sort of to the bottom of the priority list. And in fact, I've seen some commentary where for internal reorganisations, there's some commentary saying just wait until the 6 months is over because Treasury is not going to be interested in processing those applications. That might be a bit of a harsh response. They probably will assess them, but they won't be a high priority.
I guess that brings back into the point that we should be making here, which we did mention in the beginning, but let's mention it again, that these are only temporary measures. They're only in place for 6 months. And then at the end of that 6-month period, we're back to the previous regime that had a much higher monetary threshold. Well, we're talking about a zero threshold right now. The threshold in the past was 254 million or something like that, I think. Is that right?
Yeah, it's currently 275 million. And you're right, like the thresholds are incredibly high and in fact, they're high for, so free trade agreement partners, they have a threshold of $1,190,192 million, however you say it, 1.192 million. So very high threshold for free trade countries. And then for everyone else, the threshold's usually 275 million. But the other thing to note is that these changes are not to dampen foreign investments. They're not, it's a lot of the publicity has been saying, well, every transaction is going to be notifiable now and every transaction is going to be scrutinized. That's not necessarily true. It is as you mentioned before, the percentage threshold still comes into play. And it's also the ability to scrutinise. These measures have been put in place for two reasons. One is to protect Australian jobs and to support Australian businesses. And so if a foreign investor can show that their acquisition is doing that, then there's going to be no issue. The scrutiny will come where where a foreign investor is trying to, I guess, snap up something that's been incredibly devalued during the COVID period, or to take advantage of this unusual economic time. So it's really designed to protect those businesses as opposed to stop foreign investment.
And this brings me to another point that I wanted to delve into, which is the mistakes that can be made during the application process. And, I think one of the things that you're pointing out here, which I think is important to make clear, is that there is perhaps a right strategy and perhaps a wrong strategy, or mistakes that can be made along the way. So let's just perhaps touch very briefly on any issues that you have seen in the past with, applications that have been made perhaps poorly by others that have created issues where they didn't need to be created.
I think the bottom line is communication is key. So FIRB is a very misunderstood area of the law. And one of the myths to dispel is that there's actually, everyone refers to it being FIRB approval. And the approval actually comes from Treasury. So the Treasurer has the ultimate decision-making responsibility in respect to all applications that come through. And the Foreign Investment Review Board, FIRB, is an advisory board to Treasury. So the application actually is made to the Department of Treasury, and the Department of Treasury or the ATO, depending on the nature of the application, will then assess that application and then make the decision or the recommendation to the Treasurer. And the decision is made by the Treasurer as opposed to the Foreign Investment Review Board, but they do play an advisory role. So referring to it as FIRB approval is not necessarily correct, but it is kind of a colloquial way everyone refers to it. So foreign investment is a very misunderstood area of the law, and that's because there's the legislation that's at play, but in the past there's also been the policy that's been at play as well. So it comes down to in an application you need to address the national interest criteria, and the national interest criteria basically underlies every application. So to get approval for a foreign acquisition, you need to pass the national interest test. And that is not a defined term. And the government is very reluctant to give clear guidance on what that term means, because they want flexibility in how they apply it for different circumstances. And actually, COVID provides a perfect example that what's in the national interest is businesses and jobs. But that's not necessarily the case on every acquisition. So when people make an application to FIRB, because people don't understand necessarily the steps involved or what the criteria is, often they don't fully provide enough information to Treasury for them to assess the application or to understand the application. And that's one of the big hurdles in the application process. Is there's a lot of areas that are misunderstood and misunderstood in terms of how to provide the application, what information you do provide, and then how it's assessed and what criteria Treasury is looking at in that assessment of the application. And it all comes down to the fact that the national interest is not a defined term, and it's not a defined test. It's very open, it's very opaque, it's very flexible in the way that the government applies that, and they'll apply it differently based on the different transaction.
And so I guess, the point is, this is one of those instances where, perhaps it can seem like you're going through a tick a box exercise in terms of information that you're providing and answers that you're providing. But the reality is there's a lot of commercial nous and legal nous that really needs to happen behind the scenes to make sure you're providing the right information in the right way to maximise your chances of a positive outcome, rather than something that drags on forever or doesn't get you the approval that you're after.
Absolutely. That's absolutely right. You've explained that perfectly. And it's when you said about the approval that you're after, conditions can be made on FIRB approval. So often FIRB approvals, the rejection rate's very low. So usually an acquisition has a high approval rate, but there can be conditions placed on it, and those conditions can be placed on it if there is misunderstanding in that application process.
And I guess we're yet to see how the landscape will fully play out in the next 6 months as well. So whilst the approval rate may have been high in the past, maybe it'll take a beating right now. I guess it will be interesting to see what goes on in this next 6-month period. But
I guess we're in unprecedented times. And we'll wait and see what happens, because never before, I don't think, in the history of from my experience, the threshold's never been 0. So it's going to capture a lot of transactions.
Yeah. And so this is a point I think it's really important for our listeners just to understand, just for us to really ram home some of these important points. The monetary threshold is 0 now for foreign investors. So if you are acting for a foreign investor, or you're acting on the sell side for an Australian entity that's selling to a foreign investor, and the foreign investor is looking at acquiring more than 20% of the entity if it doesn't have land, or more than 10% if it does have land or is a land-rich entity, they now, no matter what they're paying, they now need to potentially get FIRB approval before that transaction can complete.
Yeah, that's correct. But also they need to be mindful that if the entity does hold land, then it's worthwhile getting legal advice on whether it will trigger FIRB now, because of the definition of an Australian land corporation. And there's a percentage holding that the corporation will, if they hold a certain percentage holding of land, then that will trigger FIRB, and they'll be classed as an Australian land corporation.
So many complexities, Jo, so many complexities.
Definitely.
That's why we have FIRB experts like you on the case.
Exactly. Yeah. It's a very complex area, and there's a lot of different nuances and different definitions and different percentages. And you think that you're all clear in one area, and then all of a sudden you realise, that business is an Australian land corporation because it holds these interests in land, and then you're back at being notifiable. So it is a very tricky area of the law.
Brilliant. Okay. All right. Well, look, I guess, do we have any parting words? It's a tricky area of the law. Obviously, be aware that there's now this absolute change in thresholds that will make a big impact if you're dealing with foreign investors who are looking at Australian assets for purchase. Anything else that you want to throw out there, Jo, in terms of takeaways for our audience?
I guess final remarks would be that if there is transactions, not to get scared off by the 6-month delay or the 0 threshold. It's not about limiting or stopping foreign investments. It's still, the Treasurer and the Prime Minister still say this country's open for business and is inviting foreign investment. So it's not about being scared off by those criteria. It's just about getting the right advice as to how you can work your transaction in to the current climate.
Brilliant. Okay, absolutely love it. Well, Jo, thank you so much for joining us on the Deal Room today.
My pleasure. Thanks so much.
Well, that's it for this episode of the Deal Room podcast. And of course, in this episode, we were talking with the fabulous Jo Wright, who's one of our senior lawyers here at Aspect Legal and who is a specialist in dealing with the FIRB approval process. Now, if you'd like more information about this topic, then head over to our website at thedealroompodcast.com, where you'll be able to download a transcript of this podcast episode if you'd like to read it in more detail. There you'll also be able to find out how you can contact Jo Wright or any of our other legal eagles at Aspect Legal if you or your clients would like to discuss any legal aspects of foreign investment or the FIRB approval process. As Jo spoke about today, there are a lot of mistakes that can be made in this area, and it's certainly one of those areas where it's absolutely imperative that you have a specialist expert advice guiding you through the process. And of course, there are many, many, many businesses and many transactions that will be captured now that had not been captured in the past in terms of foreign investment into Australian businesses because they simply hadn't met the thresholds that were in place in the past. And of course, as we said, the threshold right now for the period of time that these new temporary provisions are in place is 0. So if you're involved in a transaction, you're concerned that the transaction might trigger the requirements for FIRB approval, then get in contact. We can help guide you through the many considerations and also help you put the application in place if indeed that is required in your situation. Now, of course, we can assist on a lot more than just advice on foreign investment and the FIRB approval process. We can, of course, assist through our great range of services to help guide businesses through sales, acquisitions and mergers. So if you or any of your clients are looking at sale or acquisition, then just get in touch. As I said, you can find us on the website, thedealroompodcast.com, where you can book in initial free discussion with any of our legal eagles at Aspect Legal, or you can head over to our website at www.aspectlegal.com.au. We work with clients both big and small and have different types of services depending on size and complexity. So don't hesitate to book an appointment if you'd like to find out how we might be able to assist. Well, that's it for today. I hope you enjoyed the discussion today with me, Joanna Oakey, and of course our very special guest, Jo Wright from Aspect Legal. You have been listening to the Deal Room podcast, which of course is brought to you by our commercial legal practice, Aspect Legal. See you next time. Aspect Legal has a number of great services that help businesses prepare for a sale or acquisition, to help them prepare in advance and to get transaction ready. We've also got a range of services to help guide businesses through the sale and acquisitions process. We work with clients both big and small and have different types of services depending on size and complexity. We provide a free consultation to discuss your proposed sale or acquisition. So see our show notes on how to book a time to speak with us, or head over to our website at aspectlegal.com.au.
Ladies and gentlemen.
That will conclude this evening's entertainment.
Thanks for listening to the Deal Room podcast. To find out more about this episode and other episodes in the series, check out the show notes or head over to our website at thedealroompodcast.com.au.